A prenuptial agreement is a contract between two people planning to get married that determines how their property will be distributed in the event of certain events that end the marriage. Typically called a prenup, the agreements can help provide valuable certainty during what can often be the challenging process of getting divorced. We're eForms, the largest online database of fillable legal forms. In this video, we'll cover what to know before getting started, what Wisconsin prenups can and cannot do, and whether a prenuptial agreement can be changed. And if you're looking for an official prenup agreement form that can be validly used in Wisconsin, be sure to watch until the end of this video to find a link that can provide you with one. First, what should you know before beginning the prenup process? Because of their protections they provide, prenuptial agreements can be important legal resources. They can be particularly helpful to people entering a marriage with children or dependent relatives, or complex business interests. It may be best to consult with a financial advisor or professional to see whether a prenuptial agreement is right for you. And of course, a thoughtful conversation with your partner is essential before getting too far into the process. One factor that may guide your decision. Wisconsin is one of the 9 community property states. This means that in the absence of a premarital agreement, all property acquired during the marriage is considered to belong to both parties and will be divided equally in the event of a divorce. Community property laws make prenups especially desirable to people who are starting new businesses that may later increase in value. If you're thinking about pursuing a prenuptial agreement, know that the agreements have to be written down and signed by both parties. It's a good idea, though not always required, for each party to have a separate lawyer to review the prenup before signing. So what can Wisconsin prenuptial agreements do? Prenuptial agreements can cover just about everything: personal property like cars and boats, real property like land, and financial assets like bank accounts, stocks, and interest in businesses. They can apply in case of divorce or the death of one partner, and they can also lay out situations in which another document, such as a last will and testament, will control what happens. Prenups can cover topics like spousal support and the obligation to provide for future expenses like college education. What about things a prenuptial agreement cannot do? Although couples have a lot of freedom in drafting prenuptial agreements in Wisconsin, their flexibility is not unlimited. Prenups, even otherwise valid ones, still have to be equitable or fair. The Wisconsin State Supreme Court has set out a few things to consider when it comes to whether an agreement is equitable. The first is the terms of the agreement itself. Although prenups can change how property will be distributed under community property laws, they can't make things totally unfair to one spouse. The other factors have to do with whether the agreement was valid in the first place. An agreement in which one spouse failed to disclose important financial information would be neither equitable nor valid. The same is true for an agreement in which one spouse signed under duress, which means he or she was pressured into signing. After the agreement has gone into effect, can prenuptial agreements be changed? Yes. Like other contracts, Wisconsin allows prenuptial agreements to be modified. These are known as post-nuptial agreements. As with the original agreement, changes must be in writing and signed by both couples. For an official prenuptial agreement that can be used in Wisconsin, click the link below. And don't forget to subscribe to see other videos breaking down important legal topics.